Hello, friends. Welcome to the Your Project Shepherd podcast. I'm your host, Curtis Lawson, and we are here to teach that every successful construction project has 4 components demonstrated by the simple drawing of a house. The foundation is proper planning. The left wall is your team, the right wall is communication, and the roof is proper execution. Have all 4 of these components in place and your project will succeed. We're here to help professionals and homeowners alike make the best decisions about designing, planning, and building custom homes. If you'd like more information about how Shepherd can help you with your project or business, visit us at yourprojectshepherd.com. And now, here's today's episode. Hey friends, welcome back to a new episode of the Your Project Shepherd podcast. I'm your host, Curtis Lawson, and today I am joined by Kenneth Stevens. He is the principal or the managing partner with Stevens, Reed, and Armstrong. Is that correct? Did I get that right?
100%. Some people say Steffens, but you nailed it. So it's
all right. So you personally focus on construction litigation and construction issues, right?
That's correct. So we're a litigation boutique. So primarily what we're doing is disputes between business entities. And then, the different partners kind of focus on different things. So my area is construction litigation, primarily litigation and arbitration.
And you have some other partners in the firm that do different areas of the law, different focuses?
Exactly. So one of my partners primarily focuses on employment, labor and employment issues. So it's kind of a good mix, a good pairing. And then another one is a kind of a general commercial litigation guy. So any kind of breach of contract disputes, disputes between partnerships and stuff like that. Sometimes when the businesses break down, he's kind of the go-to guy for that. And then he also does some injury defense work as well. So,
and do you primarily work on the side of homeowners or of contractors?
Mostly contractors. I mean, a lot of what I do, I would say probably 90% of my practice is representing contractors in both commercial and residential jobs on the public and private side.
You're a very prolific poster on LinkedIn. That's how I originally found you, and then we met, I don't know, a year or so ago and had lunch and chatted. But I've been following your LinkedIn stuff really close.
Yeah.
And what I like is that you post a lot of very good, helpful information. Some people treat LinkedIn like it's Facebook or whatever, and they post funny stuff and spam all the time. But you actually post a lot of good, helpful information.
Well, I appreciate that, man. I mean, sometimes you post and it kind of feels like it might be going in a vacuum because maybe some folks like it or whatever, but you never know like what the full extent or the full impact, of what the posts are. But I try to post stuff that from a construction standpoint, some people might know, but it's just not really thinking through all the way. And then sometimes it's just stuff that maybe people don't know, you know what I mean? And I'm just kind of like, as I experience different things while working on cases, or I start to see patterns or trends, I just try to post something that contractors can look at and be like, you know what, maybe I haven't thought about that, or maybe I have, and I really need to get on top of doing this because, obviously it's an issue. So.
Yeah, I always read all those. And someone told me one time if an attorney is giving out free advice, you should probably listen to it because it's better to listen to that free advice now than have to pay for it by the hour later.
Exactly. What's crazy though is there's a bunch of folks that will pay for the advice and then still not follow it. So that's even more wild. I get folks that I advise them, hey, don't do this or do that, and then maybe a few months later, I'm like, well, here we are. It's just like I kind of told you this was coming. So. It's just one of those things, you can put it out there and hope that it's helpful. And I think for a lot of people it is. I have had folks hit me up and say, hey, man, I saw one of your posts and, it made me go in and redo my contracts, right? Or it made me, update this. So I appreciated that. I get messages, even sometimes actual mail, right? Which is pretty cool to get something in the mail and you read it and they're like, hey, just, appreciated a post on this. And so I was like, that's pretty neat, man.
Yeah. That's kind of what we experience too. We do the podcast and post stuff on social media and I never know really what the reach is. You can see the views and things like that, but you don't really know what the reach is. And it always makes you feel good to go to an event and have people come up to you and say, hey, I listened to your podcast and I learned something from that episode.
Yeah. I mean, I think there's reach and then there's impact, right? And so reach is one thing. I can look and see, this has reached X number of people according to these metrics, but out of those people, I don't know how many people I've impacted, right? And I think just like you said, when I'm at different conferences and stuff and folks are coming up and saying, hey, really like this, or, this really helped me, well, then I know I've impacted that person,
So what I wanted to talk to you today about is about reasons that contractors and homeowners get into disputes.
Mm-hmm.
What are those most common issues that arise?
Mm-hmm.
And kind of going back to LinkedIn, you made a post a couple of days ago that I enjoyed, and I kind of copied on here so I could kind of reference it while we're talking. But you made a post about accountability, and that's something that's lacking in society in general right now, right?
Jeez.
With construction issues, mistakes are going to happen, and rather than, I think the point of what you're saying is rather than, trying to cover yourself and find ways to get out of it and hoping somebody doesn't notice, and then if you get caught, everybody lawyers up. It's always going to be a lot cheaper just to go ahead and address the problem, own up to it, and go on down the road, right?
Exactly, 100%. And that's the point that I was making in the post. I think that, a lot of times things happen, and we're human, right? I mean, part of what makes us human is the ability to make a mistake, and then figure out a way to correct it, right? I mean, you learn from your mistakes, the whole nine. But I think we are in an era of just, you don't ever own up to the mistake, and it makes things way more expensive. I mean, I will see something that it may have been a $10,000 error on a, $500,000 project. And if somebody had just said, you know what, my bad, I stepped in it, I'll take the hit. Well, it's a $10,000 mistake, maybe $15,000. Everybody, moves on, calls it a day. That just doesn't happen as often as it should, and then by the time it gets to me, there's $100,000, $200,000 in damages on a $500,000 project. And then I'm sifting through all these communications, all this different stuff. And then you get down to the root of it. And it's like, wait, this is what it was, right? I mean, you all waited too long to pour the concrete. That was it, and if we acknowledge that in the beginning, just would have saved everybody a lot of time and a lot of headache. And so I'm really encouraging contractors and their lawyers on the front end to say, hey, let's try to start forcing the issue a little more, because I don't think people are as self-accountable anymore. I think that might be just a societal thing, or there's a generational thing. I don't know. But it used to be, it was self-accountable. People felt like kind of this sense of, if I did it and I know I did it, I'm not going to pay a lawyer to continue to fight or whatever. I'm just going to say, this is it. I did it. I think that now we have to force that. And so I think there's ways contractually on the front end to say, hey, if an issue arises, this is how we're going to deal with it, right? And we're going to all elect some person or go get some person, and that person's going to make a decision, and we're all going to live by that decision. And that person's going to be completely neutral. And this is how we're going to deal with that. And I think that for at least smaller disputes, that's a way to keep things from ballooning into something much larger. Because I could tell you, when there's a mistake and there is no accountability and everybody starts lawyering up and experts, the only people that are winning in that situation are the lawyers and the experts that are getting paid all this money to deal with the problem. Or figure out what somebody sitting there paying them already knows, that they stepped in it, that it was their fault, So
I mean, I get hired as an expert all the time, and I look at the situation. I'm like, man, this was a $5,000 fix six months or a year ago, and now you're paying me $5,000 on top of whatever you're paying the attorneys and everybody else.
It's crazy. It's madness, man. And I try to tell people, even before, I probably have more conversations that are statements against interest than I care to admit, right? I mean, somebody sits across from me just like we are right now. They give me an issue. Maybe it's $50,000, maybe it's a $30,000 dispute, or maybe it's $1 million dispute. And I tell them outright, this is what you need to do. You don't need to pay me. If you do this and you do it right, y'all go about it and resolve it, you will be much happier in 6 months, because what's going to happen is you're going to pay me X amount of dollars over the next 6 months, and this isn't going to be done yet. And then you're going to be upset that you're still paying me and there's no resolution to it, because the wheels of justice turn very slowly.
Right.
That's just the way that it is. I mean, whether it's arbitration or whether it's litigation, it's going to take time and it's going to be costly. And so I tell people, before you jump into this water, make sure that you are ready to swim and, like that you've exhausted all other remedies, because once you do this, you're kind of committed to it. So yeah.
Yeah. I mean, I got hired on one recently where, it was about to go to the attorneys, and somebody said, "Hey, somebody outside of the situation said, hey, I know Curtis, he does a lot of expert witness work. Why don't you get him to come in and kind of help you decide, how to remedy this before it goes to the attorneys?" And it was so simple. It was just the builder knew what he needed to do. He'd just been kicking the can down the road and hoping it would go away, and the homeowner's just sitting there getting madder and madder and madder. And so they brought me in, and I got both people to say, okay, whatever Curtis says is the way out of this, that's what we're going to do.
Exactly.
And guess what? In 2 or 3 weeks, it was done, and it was over. And
a lot of headaches saved.
If the builder would have just done what he was supposed to do to begin with, that money would have been never spent.
Exactly.
So
exactly.
It's always cheaper to work something out than it is to lawyer up. Sometimes the blame for a situation is shared. Or should be shared. Like if you have a set of plans that there's a conflict on the plans, maybe the architect and the engineer, there's a conflict there, and the builder kind of didn't go to them and kind of did his own thing to figure it out. And now you've got a problem. Sometimes I tell people to put your heads together, architect, engineer, builder. Hey, we were all wrong here. Let's all kick in $2,500 and make this thing go away. Otherwise, each of us individually are going to be spending more than that on attorney's fees. So sometimes you can kind of create a group solution to something like that and just say, you know what, we all want to make the client happy. We want them to be a happy homeowner and have a good product. And we also want to lessen our long-term liability. So let's, as a team, get together and solve this.
Yeah, I mean, and that seems like the most logical thing. And I think, in years past, or maybe decades past, that was just like kind of the go-to thing, right? But people are fighting everything tooth and nail these days. And so, I guess a forced solution is probably the best bet. And maybe they hate it at the time, but then they thank, their lawyers or whoever put it together had enough foresight to put it together. They'll thank them later because it's going to save them a crap ton of money and time, right? So one last thing on accountability that I wanted to say is it kind of goes both ways, and I think sometimes the homeowners, clients, often don't read the contract they're signing, and so you'll get in these disputes where, clearly the builder, the contractor is in the right. The homeowner just doesn't like it, right? I've seen a lot of issues with the client not kind of being accountable for the document they signed. 100%. Right? That's why, in all honesty, I say I don't think I have any cases right now where I'm representing the homeowner. And it's not to kind of like bash on the homeowner. I'm a very big proponent of like consumer rights. Like I think that, it's important. And I think that what, plaintiffs' attorneys do is very important. But I've noticed that when you're representing a homeowner and the times that I have, it can become very emotional, right? Versus commercial owners, it's a business proposition. But when you're representing residential homeowners, it's their home, right? And it is an emotional thing. It's a very personal thing. And so they take it very personal. And, I struggle with that from a logical standpoint, because as a lawyer, I can understand, as a person, I can understand the emotional aspect of it. But as a lawyer, I'm like, hey, you're dead to rights wrong here. And there's not a lot that could be done about it. And, there's no sense in throwing good money after bad. Like you kind of just need to figure out a solution. So, a lot of times they don't read contracts, but in all fairness, a lot of times they did read it and they just don't understand it. Right. And I think that's a bigger problem that's a little bit more prevalent, is that you get, whether it's a spec home builder or whether it's a custom home builder, and you have these contracts that have these provisions, whether it's the, TAB standard deal or whether it's something else. And people just don't know what they're signing, right? They don't know what they're agreeing to. And so I think the biggest thing is, what I would like to see happen is more people get lawyers, to just kind of explain it to them in plain terms. I mean, you're making probably the biggest purchase you'll make in your life, right? For most people, you would hope that they would get counsel to just say, hey, if I'm about to invest, $500,000 or whatever, in the next 30 years of my life, I kind of think it's worth spending $5,000 to, make sure I understand what I'm committing to. Yeah. Or at a minimum, they require that the contractor sit down and explain to them in plain language, hey, this is what this means. This is what that means, and write it out. Now, most contractors wouldn't do that. And if I'm the contractor's lawyer, I would say absolutely not. It's a terrible situation to put yourself in.
Yeah.
But
a lot of the contractors don't understand the contract either.
Yeah, that's true. It's true.
They're just using that generic TAB contract, exactly. which I use too. But I mean, I have taken the time to understand the contract that I'm signing. But a lot of contractors are like, it's the standard form. I just sign it.
Yeah, it's the standard TAB form. And that's dangerous too, right? As a contractor, because you don't necessarily know what you're committing to from an operational or procedural standpoint. Yeah. You have your SOPs that are for your company that have made you successful or whatever. And then the TAB has what you're required to do or what you're committing to doing. And sometimes those things aren't necessarily the same thing, right? And so you need to understand what you're agreeing to. And then the homeowner needs to understand, because the thing that I think causes, I'd say probably 90% of disputes, is just misunderstanding. Whether it's a misunderstanding of the contract, a misunderstanding of what each party thought was going to be brought to the table. A lot of times there's disagreements regarding scope, right? That's a big one. And then cost, seeing something and, I thought it was going to be this much, but now it's, because of unknown reasons or maybe reasons that should have been known, things get more expensive. And so, I think that just more transparency and understanding on the front end, clarity to make sure that both parties understand this is what I'm paying for from the homeowner standpoint and the contractor standpoint. Okay, this is what you're getting. So we're very clear. And if it's anything outside of that, whether you think it should be included or not, that's kind of not the point. We're very clear on this is what it is. And then you go from there. So.
Yeah. So just this morning, we had a client or someone who's about to sign a construction contract with us. And we had kind of a contract scope review this morning. And, one thing that we always do is, we'll go through the contract, and I don't want to, because my lawyer wouldn't like it either if I sat there and tried to explain all the legal terms. That's not my place. They need to get their own lawyer. Exactly. But I do think it's important to point out to them, here are the most common areas where there's some confusion. And this is kind of what this means in general. So like when we talk about how do change orders work, how do draw payments work, what is substantial completion? Let's go through and hit at least those 4 or 5 kind of big items to make sure that, we're looking at each other in the eye. We understand what this means, right? Yeah. And if you got any further questions, talk to your attorney, but I'm not going to read the whole contract line by line with somebody. But I do think it's important to hit the high points.
Yeah, definitely. I think that there's a way to try to do it that keeps you out of hot water. I think that it is dangerous. I can see, like I said, from an attorney to contractor standpoint, I'd be worried about, arguments of misrepresentation.
Right.
Because that, like you said, the main thing is that there's this lack of accountability on what you signed, right? And so how do you get out of that? When they were explaining this to me, they said it meant this, and I thought that, and that's why I signed it. And so, there's this contractual concept of fraudulent inducement, right? That's what it's called. And they fraudulently induced me to enter into this contract by sitting down and saying that clause 1 meant this and clause 2 meant this. And had they not have made that representation, I would have never signed the agreement.
Right.
And so that voids the agreement, right? So I think if you're doing it as a contractor, I think you do have to be very careful as to just be surface level, right? And I would definitely follow up, that conversation with documentation of, hey, if you're talking about substantial completion and you're explaining it, that needs to be in writing what you've explained, right? And that needs to be what you follow. Because once you put it out there that that's what substantial completion is, you're bound to it. And if you're not following that, then you catch yourself in hot water. So I think from a contractor standpoint, I think it's important that you do make sure that the customer understands what they're signing. And so I am a big proponent of, having a upfront, candid conversation with them. But I think that you need to build in protections to make sure that it's not something where they're saying you're misrepresenting things and, can hit you with these DTPA claims and fraud claims and all that stuff later.
Yep. One thing that I like to point out also is that, the contract is kind of the mechanics of how we're going to work together. But one of the most important documents or parts of the contract is we've got our main body, the main TAB, but then we've got Exhibit A, specifications, Exhibit B, allowances, Exhibit C, draw schedules. The specifications document is, in my opinion, like the most important one in there because that outlines what I am giving you for what you're paying. And I tell people, if it's not listed on here, you're not getting it.
Exactly.
So before you sign this contract, read through this on your own, make sure that if you think that you're getting a epoxy coating on your garage floor, make sure that's listed in that contract.
Exactly.
And don't just assume it's on there because you mentioned it 6 months ago in a meeting.
100%. I think doesn't matter whether it's, whether you're doing residential, commercial, you have the baseline agreement and then you have the exhibits, sometimes general conditions, specifications, whatever the case may be. And so with the TAB, like you said, you got the specifications and the other exhibits. And I think that, most people probably just look at the baseline agreement and then all the exhibits, they're kind of like, they kind of skim those. Yeah. And I agree with you 100%. I think it's very important that, specifically any scope document, which is basically what the specifications document is, that has to be kind of meticulously reviewed, right?
Yep.
I've seen people treat like the schedule of values as a specifications document, and it has everything kind of line itemed, and it's like, hey, you need to drill down more, right? Because sometimes what I see is kind of the main thing that kind of prompts disputes arising out of specifications is just there'll be like a broad thing that's supposed to be included, right? But then there's other smaller things that have to be done in order to accomplish that larger thing. And sometimes the homeowner just assumes that that's included, which I think is kind of, natural for them. And but the contractor understands that, hey, there's some additional costs that are going to be associated with it. And they just don't, the two don't meet their minds don't meet on that. And then that comes up later and there's an issue. And so, I do think it again comes back to just a very candid conversations to make sure y'all have the same understanding of what's included and what's not, and being as transparent as possible. And then, there's some agreements have language in them that pretty much makes it arguable that certain things should be included, right? Like things that are inferable type of like that inferable language, which I always try to drill down on that from the contractor standpoint. I'm like, hey, we're going to focus primarily on from a scope standpoint, we're going to make sure that we're only responsible for doing what's in the scope document. And so, like you said, if you want it done, you better make sure that it's on this paper. And then we even include a line that normally says anything that's not on here is specifically excluded. Yep. Right. And so it's like, we're not telling you, like, nothing's inferred. If it's not on this paper, it's specifically excluded. It's expressly excluded. And courts have made it very clear that if you expressly exclude anything not included in the document, you're kind of you've kind of made it very plain
Yeah.
to them. So
even back, like, I don't know, 20 years ago, before I was sophisticated and dealing with construction issues, when I was just getting started, someone gave me some advice on my very simple contract that I had at the time, to just add the sentence that says, "Do not assume that anything is included in this contract. In fact, if you do not see it listed here, it is specifically." I mean, it was a very simple statement that we added to that contract, but that one's always stuck with me as a very powerful thing that
no, definitely
to have in there.
Definitely it's a way to eliminate a lot of that uncertainty argument, and that inclusion argument, because a lot of times, like I said, the scope will have certain stuff in it, and it may not drill down on some of the underlying things that are required to make that happen, or maybe they're not necessarily required all the time, but in these circumstances, it is required, right? And so maybe there's some additional drilling or some additional support that needs to be done, or some just, like, for example, the project I'm dealing with right now up in Dallas, it's our construction project for the winery, right? And out of nowhere, we find out we got to do some additional saw cutting, and so it's just like change order, right? Significant change order. And so naturally certain plumbing and stuff was included, and so arguably that's part of the plumbing. The change that they said made was part of the plumbing, right? But I mean, I've been doing this long enough to know, okay, that's X amount of feet of additional saw cutting. I'm not gonna tell the contractor, no, you've got to include that, right? That's just not that's not the same thing. There's a sub that's got to do more saw cutting, and so it just is what it is. I mean, that's not something that could have been anticipated, and so I'm unfortunately having to pay more money on the change order. It just is what it is, right? But if I were, maybe, like you said, less sophisticated, maybe I find myself in a situation where I'm arguing about that, and we're spending money, and then the project slows down and there's delays, and we kind of get back to that situation that we talked about. So
just having a high level of clarity and detail in your documents is really important. There's a lot of different ways to accomplish different tasks on a construction site. You could say install faucet in bathroom, right? Well, you would assume that maybe that a faucet is something that you drill a hole in the countertop and you stick it in there, right? But what if that client goes and picks a wall-mounted faucet that requires certain support? It requires a special valve inside the wall, and that client, doesn't want to pay a change order to have to add that extra stuff. You could have made it a lot more clear in your scope document saying, this includes installation of a deck mounted three hole faucet, right? Very clear. So I do like a little class with contractors talking about this particular issue. And the illustration that I like to do is I'll get like a generic architectural drawing of a powder bathroom, a sink, a toilet, 3x5 room, super simple. And I say, okay, describe to me what you're doing in this bathroom. Invariably, people will say, we're install cabinet, install countertop, install sink, install toilet, install tile. Okay, all right, let's pick apart where that's going to go wrong, right?
Exactly.
So, I mean, like, if you ask a homeowner to close their eyes and imagine the powder bathroom, how are they going to describe it? What material is the cabinet? Is there wallpaper on the walls? Is it 2 sconces versus 1 sconce?
Exactly.
Is it a flat mirror or a hung mirror? What kind of faucet is it? I mean, there's a million levels of detail that you can go into on that to protect yourself. And to me, that's where I've seen the most disputes personally as a builder on the receiving end of that, and also as an owner's rep and as a consultant. Most of the disputes that I've seen have been from the owner not understanding what it is they're buying.
Yeah, definitely. I think that you hit the nail on the head with details. I mean, these generalities are bound to cause problems, right? Because anytime you just have a general description or lack of a description, rather, there just leaves room for two people to have differing interpretations of what the same sentence or the same inclusion mean, right? And so I think the more detail you put in there, the better off you are. And then again, you need that exclusion language that, hey, if it's not on here, then it's not included. And so I think that's a really good point. Just making sure that, the level of specificity that you put into that specification document, I think is very, very crucial. And then making sure that the homeowner commits to those certain details, making sure you get them to commit to as many details as possible. But it cuts both ways though, right? So from a contractor standpoint, let's say you do have something that, you've committed to in there and maybe for one reason or another, it's more difficult to accomplish or the cost is more than you anticipated. Well, you've got to live by that too, right? And so
it goes back to the accountability.
Exactly. You got to be accountable for it, right? I mean, it's just one of those things, right?
Yeah.
I mean, it's just one of those things.
We're on a project right now where we're almost finished with it, where we took this project over from another builder, which unfortunately we do a good bit of. Mm-hmm. But the previous builder, the client had signed a contract with based on no set of specifications. It was just the TAB main contract with no specifications listed and a partial set of plans. It wasn't even a full set of plans. It was like a floor plan and a couple elevations, and that's it. And they signed a $900,000 construction contract based on this. Yeah, it's insane. And sure enough, they get halfway through, and guess what? There's all kinds of disputes. And anyway, that guy ended up getting fired. We ended up stepping in and taking over. But the house that we're finishing right now, that we ended up building, is totally different from the house that was on paper that the other builder was selling them. This is, and it went from $900,000 to $1.6 million.
That's how it always happens.
But guess what? That guy had, in a 6,000 square foot house, he had $30,000 worth of cabinets. Mm-hmm. Well, it's $120,000 worth of cabinets. So, they did not understand what it was that they were buying. Mm-hmm. And the contractor, I don't know if it was malicious or not, if he intentionally kind of undercut it to get it under contract, hoping they would just roll with it. But it was a bad situation, and it cost both of them. I mean, I think they both ended up spending $50,000 or more with attorneys just to get it terminated, right? So, all that could have been saved by, the builder providing a high level of clarity and the homeowner also questioning, hey, what am I buying? Mm-hmm. Why isn't there a better description of what I'm buying instead of shaking hands and trusting them?
Exactly. Yeah, I think that in the beginning of these contracts, or when people are entering into these agreements, I think there's a high level of excitement from the homeowner. Yep. They're ready to get it done, and I think that the builder sees a sale, right? They're excited, and I think that both need to just kind of slow down and understand that it is a significant transaction that shouldn't be entered into lightly. And then I think the other piece of it is, and this is another thing that I've noticed, is kind of like the era we're in. There's this people don't like to rock the boat, right? Everybody wants everybody to be comfortable. Everybody's very friendly. Everybody's non-confrontational, right. Put it that way. And it's just something that I've noticed. People just kind of go along to get along, instead of when their gut is telling them, hey, this isn't quite right, I should probably say something, or I should probably raise the flag, or say, hey, what's going on here? They don't do it. They just kind of like, oh, it'll probably just work itself out, or it'll probably just, and then they get down the road and then they come to me and they're like, yeah, and I kind of had a feeling that blah, 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 blah. And I'm like, well, did you say anything at that time? No, I thought he was a good guy, or I thought that. I'm like, that's an expensive bet, like that's an expensive gamble. And so I tell people, look, you're getting ready to invest a significant amount of time, a significant amount of money. They're not your friend. You've got to ask the tough questions and make sure that the details there, and be very transparent and require a high level of transparency, because once you're in it, it's too late, right? And so do your diligence and make sure that you have dotted all the I's and crossed all the T's, because once you are dealing with that person, you're kind of stuck with them for a while, because it's expensive to terminate. I mean, I tell contractors all the time, my clients that are takeover folks that take over new jobs, I'm like, hey, when you go into this takeover job, you got to make sure that you're real solid, because those are very dangerous projects, man. So, kudos to y'all for being able to do a lot of those and complete them successfully, because those takeover clients are high maintenance. They're emotional.
They've already been burned.
Been through a lot. Yeah. So they have, by that time, they're no longer non-confrontational.
Right.
They're very much willing to ask the tough questions and micromanage and all of that. And sometimes it's very difficult to deal with.
The good thing that we found is, if you do have a good process, and if you do communicate well, if you do good quality work, if you're honest, it's pretty easy to gain their trust. If they can observe that you're operating in a totally different plane than the previous guy operated, it's usually pretty easy to gain the trust. But yeah, it's important to maintain that trust. And it's important not to overpromise too, which was actually kind of my next item. That something that I see a lot, and this goes back to kind of pre-contract initial conversations. I think there's a lot of overpromising that takes place.
Yeah.
Oh, we got that for you. We'll do that for you. Oh yeah, we can pull that off,
exactly.
Right? And the old phrase, it's under promise and over deliver, right? I love that that mantra. But yeah, I see so many contractors saying, "Oh yeah, we'll do that for you. We got it." When it comes time to execute it, they can't execute it.
Yeah, I see it a lot in two different ways. Just cost and time, right? The big one though lately that I've seen, especially in the commercial world, is time. In the residential side, I always see cost, right? I mean, the amount of projects that are underbid, and then they get hit with some large change order on the residential side is just insane. Or God forbid they get them in just a regular cost plus, and it's like there's no guaranteed maximum price or anything like that. I've seen those go just wildly out of control. $200,000, $300,000 remodel or build enter the $1 million mark, and it's like, how did this happen? Right. And so it's because the contractor came and said, yeah, we could do this, we could do that. And, we X, Y, and Z and A, B, and C, we'll throw that in. And then the next thing you know, it's just grown astronomically. Right. And then on the time side, I think that's pretty frustrating, because people will say, people set their lives up, whether it's to move into their new home or, to get their business started based on a timeline that they're given, when that timeline, for anybody realistically looking at it, that was never going to happen. You're not going to build this in 180 days. You're just not going to do it. It's absolutely, anybody that's been in construction knows that you're not going to do that. But they say, yeah, we can hit that. We could probably hit substantial completion. We may have some punch list items that we need to get done.
I've heard that.
But yeah, we'll just have that. We just punch list that stuff. But no, you can't punch list that stuff, because you're not even going to be able to get a CO, before doing that. You couldn't even get a temporary CO, if you just try to throw that stuff on punch list. So yeah, I think that's the main thing is, time and costs. It's a lot of, I don't know if it's malicious or it's just like people are overly ambitious, but either way, got to be a little bit more realistic.
Yeah. And the other one that I've seen a lot is people taking on a bigger project than they're really qualified to take on. Like that kind of over-promising. They're like, oh yeah, I can build that. I'll figure that out, right?
Nightmare. I mean, I see that often, man.
We've seen so many cases that we've either been an expert witness on or got hired as an owner's rep on, where the builder has never built like a high-end modern house. They've only built production homes or spec homes or whatever, and all of a sudden they get hired to build a $2 million super modern house. They're like, it's just construction. I can do that. Right?
Exactly.
And then they get into it and they have no idea what they're doing. And oftentimes it's their trade base that's not qualified.
Exactly. That's what I was going to say. The subs, man, they're like, oh, it's bricks and sticks. We'll be okay. But the subs that jump in, because a lot of times and it may not even just be from the standpoint of knowing how to build it, because to a certain extent, maybe it is construction, maybe it's an upgrade of materials and things of that nature. Maybe the process changes some, but a big part of what I'm seeing is just they're undercapitalized. They are not in a position to, do this large of a project and then, go 30, 45 days without getting paid. Like, they need that money almost immediately. And so they're undercapitalized and they're just not able to deal with the financial aspect of it or the financial strain that comes with that large of a project. And it takes a lot of them out. I mean, they're excited about getting, a 6-figure or 7-figure scope of work. And then they just can't handle it. I mean, they bow out, and it screws everybody over when that happens, when it's a sub trade for sure.
Yeah. And a lot of that goes back to again the subs. So let's say you've got a plumber or an electrician that you usually use on $50,000 bathroom remodel, and now you're asking them to do a $2 million custom home. He might be able to do the wiring and the plumbing for it, but maybe he doesn't have credit terms at his suppliers, or maybe the GC doesn't have credit terms with these suppliers, and so they have to write that check every single week.
Exactly.
Or that plumber is used to getting paid every Friday at noon. Well, now you're asking that plumber to go 30, 45 days without getting paid, and so that forces the GC to pay him. Now the GC is cash poor.
No, you're exactly right.
And the whole thing snowballs.
You get, a lot of times the way that I see it is labor. Some folks are used to paying their labor almost weekly or whatever, especially in residential, they're used to paying their labor weekly, and then maybe they'll jump on a commercial job, and it's not going to happen. They're just not going to do it that way. And so they freak out, and, liens are getting filed and all that different stuff because people down the line are expecting to get paid and they don't, but that expectation wasn't realistic to begin with. Right. And so that's a huge problem. I mean, you have to play within your experience level, and you have to play within the level of, the size of your company, what you're well positioned for. And I think I've even posted that a few different times on LinkedIn that, hey, every job, although it looks like a huge opportunity, it's probably not the job for you. If you look at it and, you're like, I don't think we're in a position, or you even have maybe an inkling that you shouldn't be doing it, don't do it. Like, just don't do it. Right. You've got to, sometimes growth. And this is just speaking from an entrepreneurial standpoint, because like I said, I have other businesses and ventures. So this is not even Kenneth the lawyer. This is Kenneth the entrepreneur talking. Growth is good. Growth is good. Hypergrowth, terrifying. I mean, you grow too quickly, it can kill you. Yep. It can kill your business. It just is the way that it is. And so, methodical, measured growth, beautiful. Hypergrowth, you got to make sure that you're prepared for it. And that takes a lot of businesses out. So just don't bite off more than you can chew. Man,
that's fantastic advice. I mean, I say a lot of the things I say because these are mistakes that I've personally made in the past. Now, I feel good in saying that I'm the kind of person who holds themselves accountable. And if I make a mistake, I fix it, right? So a lot of the mistakes that we've talked about, I've made them 10, 15, 20 years ago, or yesterday maybe, right? But I've owned up to it and fixed it. But what you said about growing too fast is spot on. I guess about, what was it, Hurricane Harvey, that was like 6 or 7 years ago now, something like that.
18, right? 17, 18.
Yeah. I had a decent sized staff. I think I had 6 or 7 people working for me, but when Harvey hit, every contractor in Houston got insanely busy. So I'm thinking, hey, I'm going to capitalize on this. I'm going to hire staff. I'm going to take every single job we can get. And, overnight almost, we doubled our staff and we took on so many jobs. And I was like, we are in the money.
Yeah.
Right?
Yeah.
And we did not have the level of organization to maintain that. And we actually made less money doing
way more work,
doing double the work.
It's terrible, man.
It was, and as soon as the Harvey work dried up, I had to let all those extra people go. You know,
exactly, man. I tell folks all the time, it's about, businesses, you're kind of doing this, right? I mean, it's always kind of these ups and downs. It's entrepreneurship, right? But you want the trend to kind of be an upward trajectory. And as long as it's kind of this methodical upward trajectory, you ride the highs and lows and what have you. If you find that any like year or any 6-month period or whatever, you just kind of catapult up to this, you probably need to be a little leery, right? Especially in a service-based business, right? Because in a service-based business, it's labor, it's manpower that you're going to have to keep sustaining that. So as for example, a law firm, I'm very cognizant of not taking on some massive, I would never get a project that's like $1 billion dispute, right? I mean, the amount of people we would have to hire to maintain that. And so if I found myself in that situation, I would have to look at that very carefully, right? Very carefully, because again, I can scale up, hire 10, 15 lawyers to work on that case and just that case. But then after that case, I have to continue to feed that machine, or I have to cut that part of the machine off, which feels kind of like very mercenary. You know what I mean? And that's not something that I'm really here to do. So for us, it's always been about just methodical growth. And it's the same thing, since we're talking in entrepreneurship on the wine side of things, I made a very similar mistake in the product offerings, right? I mean, we grew our product offerings very quickly as a wine brand. We grew to 13 wines in like less than 3 years, like maybe 2 years. We had scaled up to 13 different SKUs. And very quickly, I was like, this is very difficult inventory to maintain for 13, right? You got your best sellers and you got to make sure you got a lot of inventory of those. But because you now have 13 offerings, you have to have some inventory for all of them. And that becomes more difficult to manage. And so I was kind of like, oh, well, some of these may get sunset, right? It's just like, we may not be offering some of these. But it's just, you learn from those mistakes. And I definitely, as the CEO of the company, was accountable. It's just like, yep, we're going to kind of just have to let people know we're sold out. I'm sorry. My bad.
Well, since you brought it up, go ahead and give everybody the name of your winery and tell us about that. I was going to wait till the end, but we're in there. So go ahead.
No, it's all good, man.
Go ahead and tell everybody about it.
Yeah, so I own Pure Noir Urban Wineries. We are a winery in downtown Houston. So we have a winery and tasting room, but we make all California wines. We source the grapes from California. So like I said, we're up to 13 different wines, but kind of the core of our portfolio is maybe about 6 or 7 wines. They've won a lot of awards. We've had the good fortune to recently win, the rodeo competition. We had one of our wines got a double gold there, and we've got a few of them that have gotten double golds. We've had like master sommeliers taste the wines and have loved them, but what we really appreciate is that the portfolio is pretty diverse, and even the individual wines are diverse enough to where people that come in and don't know a lot about wine, when they visit our tasting room, they'll taste our wines and actually appreciate them as well. They don't have a bunch of sugar in them. It's not like, this kind of sugar juice situation. It's really good quality wines. But we just appreciate that they're diverse enough to be loved by those with really experienced and sophisticated palates and those that are new to wine. Because most of the people that come into our tasting room downtown, they don't have a lot of experience with wine. So it's just, trying to introduce wine to this market, because we're not California, obviously. Downtown Houston, most folks are just kind of traversing work or coming in from the suburbs, and maybe this is their first wine experience. And we're happy to be able to offer that for them.
And you guys are opening a new location in Dallas, which you referenced you're working on right now. Got construction happening?
Yeah, that's a construction project that's going on up in Dallas. We're in the Victory Park area. Really excited about it. We think it's going to do really well. There's a lot of excitement in the city about that experience because we kind of track the analytics and everything, the people that visit the website and that have come to the tasting room. We get a lot of people from Dallas. Like when they come in and they visit from Houston, they're coming in visiting Houston from Dallas. They're coming into the tasting room. So we have a huge mailing list and all of that. And we're getting pinged like every day, every few hours. Hey, when do y'all open? When do y'all open? When do y'all open? So it's really antsy, but the construction is going good. You know, we got a good group up there, and our GM's kind of managing that up there as well, which is nice. So
awesome. Well, good. I'm glad we got a chance to plug that, because
sure.
I definitely wanted to bring that up. So back to our construction discussion.
Sure.
So communication is kind of the next thing that I wanted to talk about, and in my experience, kind of why people get into conflict, just a lack of communication. And I think that kind of going back to accountability also is part of this, but I think sometimes contractors are very slow to give bad news. If something does come up, that they're scared to mention it.
Yeah, definitely.
And the bad news doesn't get better with age. It's not like wine.
You gotta just pull the Band-Aid off, man. I mean, and it kind of goes back to what I said earlier, right? I mean, it's just there's this thing now where people just kind of go along. They kind of go along and hope that it goes away, right? I've had contractors that gotten sued and, you know, just ignored it. Just outright ignored it. And I mean, talk to me on a regular basis, but just ignored it.
You get a certified letter in the mail and you just...
Yeah, and then it becomes a judgment, and, you know, it's a default judgment because you didn't answer. And then at that point, that's when they call me. And I was like, I can't do a lot at this point, right? You called me 3 months ago, I could have helped you out, but you can't. The longer you ignore problems, the worse they get, right? It's just like any kind of disease of the body or anything. If you think about your business or the project as the human body, if there's a sickness, yeah, maybe it starts off small, but you ignore it, you ignore it, and it could become, unfortunately, terminal. It's pretty morbid, but when you think about it from that standpoint, I think it makes it very real for people. Small problems become big problems become business killers. And so I think, you know, you got bad news, yes, first try to fix it, because I'm a big proponent of, if I'm going to be delivering bad news, I want to deliver it with a solution.
Exactly.
Right?
Yes.
So I'm not just going to call you and say, hey, Curtis, you know, we stepped in it, our bad, you know, don't know how to, you know, just like, good luck, you know. I mean, I normally am like, hey, this is what happened. It's not ideal. It's our fault, 100%. And I've done this recently with a client. I've called and said, hey, you know, this happened. I'm sorry it happened. It's not ideal, but this is how we're going to fix it. And it's going to put you're going to be in a very similar position. You know, this is how we're going to fix it. And worked out beautifully. And what I originally thought was a problem wasn't even a problem. Like what I thought we did and was a problem, it actually was not, right? But just that client will forever respect the fact that I picked up the phone and called them, because had that actually been a problem, you know, I had already come up with a solution for it, but more importantly, there was a level of integrity there for me to just pick up the phone and let them know what had happened. And so I think that's something that contractors need to do a better job at. I think that, you know, people in general need to do a better job at that. Just recognizing that something happened, trying to figure out solutions that are options, and then communicating that and just kind of falling on the sword. Like, hey, I did it. This is what it is. This is how we fix it.
Or even if it's not a problem necessarily, even if it's just a delay, whether it's weather or whatever it might be, you know, again, this is it's very personal. It's somebody's house. Oftentimes they're selling something else and moving in, or they're renting and they have a lease that's running out. They have to move in on a certain date, and they're counting on you to communicate to them if there's a delay or not. You know, you're trying to plan an opening date for a business and get inventory in there, whatever it is. But if you're not communicating and saying, you know, hey, we had these weather delays, it pushed us back a month, so you might need to extend your lease for a month or try to find another place to live because you can't move in here yet. But just communicating that and making sure that you're ahead of it, and you don't get a phone call that says, hey, we're moving in next week.
Yeah, exactly. Yeah, I think the earlier you let people know, the better they can plan for it. I mean, that's what it comes down to. And it doesn't matter whether it's a time situation, whether it's a financial. Like, if it's going to cost me more money, let me know sooner rather than later so that I can start reallocating and moving funds. Don't call me like right when you need the money and say, hey, I need 40 grand, right? It's like, wait a minute, what happened?
Yeah.
You know, so the sooner I know, easier it is for me to adjust to it.
Yeah, which brings me to a change order. Speaking of dropping large amounts of money on people, there's two kinds of change orders. There's a change order of necessity, where it's like, hey, we have to do this either because the plans were wrong or there's a condition on the site and we have to do this. Like, hey, we didn't know that plumbing was at a different place under the slabs. We have to saw cut it now, right? Exactly. So that's a change order of necessity, right? And then there's the change order of, hey, that's prettier. I want to do that instead, right? Mm-hmm. Or I want to move that cabinet from point A to point B. So I see a lot of conflict when it comes to change orders, and sometimes it's not clear which one of those two types of change orders it is. Mm-hmm. And then sometimes it's people just do the change order without getting approval, mm-hmm. and then they ask for payment. Mm-hmm. And it's like, if there's a change order, you've got to stop what you're doing, write it up, assign a cost to it, and present it to the client and say, Mr. Stevens, this is going to be an extra $20,000. We have to do it because of these conditions. Or you want to move that cabinet, it's $20,000. Are you okay with that?
Exactly. Yeah.
Don't just do it and then hit them with a surprise bill at the end of the project.
Exactly. And I don't care like the relationship or like how good of friends y'all are or whatever.
How much of a hurry you're in.
Exactly. Because what you see is a lot of stuff, a lot of direction in the field. Oh yeah, we want to move that over to there. And we can get the paper. Yeah, we'll sign it up. We'll paper it up. Like, it's just, do all of it on the front end so that it's not, coming back to bite you, because people's memories get really, really, really short. when it comes time to actually pay for it or amend it and what have you. So definitely, make sure that that's all clear on the front end, like you said. And I think that something you said earlier helps with that, kind of having an understanding, making sure that both parties are on the same page with regard to what the change order procedure is, right? Understanding that, hey, this is who is going to have the authority to make changes. This is who's going to, if a change order comes up, unless this person gets this signed, I'm not going to be able to do it. The contractor making that very clear. Unless you all sign this change order, I'm not going to be able to do the work. So your project can be delayed. And so, I'll keep asking you, but I'm not going to go and just do the work. So you're going to want to make sure that that's able to be done. And then the same thing with on the contractor side. Hey, you can't just get one of the sub trades to agree to something and think that it's binding on the GC, right? Whether it's the superintendent that's out there or whether it's the PM, different organizations do it differently, but my PM needs to agree that this is what we're going to do and that there's going to be no added costs or that it's not going to impact the schedule. The fact that, a sub trade or somebody that was just out on site said, yeah, we could do that. It won't add any time or whatever. Like you can't do that, right? I mean, you can't take that as law. So I think understanding what the change order procedure is going to be is critically important.
Yeah, and we, our policy is, and I think most builders' policy is, change orders should be paid in advance or paid at the time the work is performed. I've seen a lot of disputes where you get down to the very end of the project final payment and the GC hands the homeowner a summary of all the change orders. Yeah. Hey, here's an extra bill for $100,000, and they're like, I don't have $100,000.
Yeah, exactly. No, I hear you, and I think it's a balancing act. I think ideally, it would definitely get paid up front. I think it needs to get paid on at least the draw that is performed. Yeah. Right. I think you definitely don't want to float all the change orders to the end. That's a nightmare. That's a recipe for disaster. I think doing it at least in the draw, right? I think that's what needs to be done. But it's interesting they got that law now that if the change order is over a certain amount, I mean, if there's a change in the work over a certain amount without an executed change order, the contractor doesn't have to perform the work. So that's used to be that if there was additional work or what have you, you could try to force the contractor or the sub to do the work, and then you would say, oh well, we'll get that figured out. But now they can't be forced to do anything if they perceive it as a change. So.
Yeah. Last thing I wanted to mention is kind of a way to protect yourself and avoid disputes. And this is something that we've had a lot of guests on to talk about over the last year or so, is kind of using third-party verification and inspections to protect yourself and the homeowner and avoid disputes. So if you've got, if there's an architect, a structural engineer, and then various types of inspectors out there, I think a lot of builders and contractors try to avoid having those inspections because it's holding them accountable, right?
Exactly.
It's like if their work's not to the plans, the architect's going to catch it and is going to call them out on it, right?
Exactly.
But what they have to understand is that by having these additional people out looking at their work, inspecting it, and signing off on it, if something comes up a year from now, that's more protection for them.
100%. It's a neutral third party or disinterested third party that is, verifying, hey, this was done correctly. And so it definitely makes it a lot more difficult for a homeowner to bring a claim, right? I mean, or at least one that can be sustained if you've already had a third party inspector come in and say, hey, this looks right. It meets the specs, right? And it meets the code, and all the I's are dotted and all the T's are crossed. So I think that, I think that's a really good thing to have done. I mean, a lot of times you'll have people that think that just if the city approves something or just whatever, that's fine, but that's just not the case, right? Yeah. And so
the city is there to inspect for building code.
Exactly.
They're not there to inspect for fit and finish. They're not there to inspect for adherence to the plans.
Exactly.
They're there just to look at code, and let's be honest, they don't even always catch all that.
Yeah, 100%. And so it is important to have someone that can come in and verify that everything is done in the way that it should have been done, so that you don't, get bit later. And that's both, like you said, on the contractor side and on the homeowner side.
Mm-hmm.
If I'm a homeowner and I'm getting a custom home, $2 million custom home built, you can believe I'm going to either have the architect that's doing the administration of the contract and the inspection. I mean, even on our small project in Dallas, it's not anything significant, but I've got an architect doing administration of the contract, and I'm somebody that probably could, look at it and determine, okay, this is, being done to spec or whatever. I've looked at enough plans, but I'm like, no, I need an architect that's going to tell me, hey, Kenneth, you can release this money, and hey, this is done, or no, we need to get them to come back in and do, A, B, and C. And so I think that's critically important, and I think it protects both sides.
Yeah. I mean, and it's usually not a massive amount of money in the overall scope of what's happening, right? Like the architect doing CA might charge a few $1,000s.
Exactly.
The homeowner hiring an owner's rep, it might be a few $1,000s, depending on how big the project is, right? The structural engineer might charge $350 or $500 to come out and do an inspection. When you're spending a couple $1,000,000, probably should go ahead and spend $5,000 or $10,000 to do all the checks along the way to make sure that you're getting what you paid for, but also that it's being done, so that your property is protected long term and your interests are protected long term.
Yeah, 100%. I think the contractor also on the front end, if that becomes your policy that you are going to bring in an inspector, or you're going to let the homeowner bring in an inspector or whatever, and you're going to adhere to what that inspector says, you just kind of build that into your pricing, right? Know that, because I think a lot of times the hesitation for the contractors is, it's going to kill my margins. They're going to come in and they're going to, find all these little nitpicky things that aren't, it's like, look, you want that additional layer of protection, right? You want to be able to say, well, look, not only did we say it was done right, but this inspector said we did everything right. And so I think or this architect said we built it to spec. They approved, they certified the payments, gave us substantial completion. So,
well, and as the contractor, like that doesn't have to come back and bite you if you're structuring your subcontracts properly. You can protect yourself. Like, don't give your framer the last 10% of his draw until it's been signed off on by the engineer. I mean, trust me, if he wants that last 10%, he's going to come back and do that punch list.
Exactly. No, right? You're exactly right. You can build a framework, a contractual framework to make sure that, it doesn't impact you much at all. So I think it's a good point.
I mean, that does go back to having trade partners who are sophisticated enough to handle that. and who have the financial means to where that last 10% being held for an extra 30 days isn't going to put them out of business.
Yeah. I mean, it's always a challenge. I understand with some of the sub trades, the frustration of that 10%, because a lot of times, especially some of the ones that finish early on, maybe some of the dirt work people and different stuff like that, like they feel like, well, we're financing the entire job. Like our 10% is being held up way too long. So I get it to a certain extent, but with other sub trades in particular, I mean, I think it's a very smart way for a GC to deal with the situation. Is to say, well, hey, until we get to the end and have this punch list, there may be things that need to be corrected, and we're not going to be able to pay you until we get these things corrected. Yeah.
I mean, our policy is once you are done on the job site, you get paid. Like the foundation guy, we're not going to hold his until 18 months till the end of the job or whatever. Once we get through engineering inspections and kind of get his portion signed off on, I'm good to let him go. Yeah. The dirt work guys, same thing. But and the framer, hey, once we get through all the framing punch list and all the other trades have done their rough-ins, okay, you're good, right?
Yeah.
But HVAC, plumbing, all those guys who go all the way to the end of the job, we're gonna hold up a final payment until everything's
exactly.
It's commissioned, it's working, and everybody's good.
To make sure that everything is good, because sometimes it looks that way, and then stuff pops up, man.
So kind of the last thing I wanted to say and wrap up is I think all the things that we're talking about, even though we've been talking about it in relation with contractors and homeowners, the same advice kind of goes to contractors dealing with their subcontractors. I mean, the same thing. So like when a contractor executes a subcontract with his plumber, be very specific in what that guy is supposed to do. I don't know how many plumbing bids I've seen from subcontractors that just say, plumb house, $32,000.
Yeah. Or, I mean, at least you got something on paper. I can't tell you how many that. Okay. Well, that's, I was going to say, I can't tell you how many I've seen where there is no agreement. It's just literally a text or an email, or they're like, it's just the guys that I use all the time. I'm like, I'll see the text, or I'll see the email, or I'll, they'll mention the conversation. I'm like, well, do you have an MSA with them? Because I mean, like, then, I'm maybe a little bit more understanding if you've got an MSA in place and you're just kind of sending them out to different jobs. But without at least a master sub agreement, I'm just kind of like, you're just out here naked, right? Like, you're like, what are you doing? So I think that you see it a lot more in residential for sure, that people just have relationships with these guys, and they just, play it fast and loose. But you got to have agreements in place. And like you said, they should be just as detailed when it comes to specs and expectation setting, because that's how you avoid those situations where that sub gets in and they've bitten off way more than they can chew, right?
Just like anything else, like plumbing, for example, there's 20 different ways to terminate the water coming out of the wall, where it's going to attach to your sink and your toilet or whatever. And, I've seen a plumber rough it in and then a homeowner come in and say, why was it done like that? Well, that's the way I always do it.
Yeah.
Well, that's not what I wanted. I didn't want a plastic PEX fitting sticking out of the wall. I want a copper fitting coming out of the wall. And then the sub's like, yeah, but those are $50 extra for every one that I have to do. Well, that's what I wanted. And then the GC has to decide, is he gonna make the sub do it and make the sub eat it? Is the GC gonna eat that cost? So, it's being very, very specific with the subs all the way back at the beginning when you're issuing those POs, if you're doing that, which you should. But don't work off of a text message.
Exactly. or a handshake, just a conversation that you're trying to recall, or an email. Just get the agreements in place. And I think that I'm a big proponent of MSAs, even if you're not going to use that sub a whole lot. And the only reason I say that is because a lot of times to try and get a subcontract, I understand the frustration of trying to get maybe a less sophisticated subcontractor, or even sometimes a sophisticated one. There's a struggle with trying to get them to execute a pretty dense, maybe a 2-page or 3-page agreement over and over and over again, right? And every time you're they got to review that and all of that. Like, but if you can sit down and get them to execute, one very comprehensive agreement one time, y'all discuss it, y'all are on the same page about that. Then all you're doing is issuing work orders, right, on your next houses. Make sure your spec document is down packed, right? You got a really good spec document, spec exhibit, and it's like, okay, well, this is your scope of work. This is what this is what you're going to be doing. This is how much you're going to get paid. If there's any modifications from the MSA, you can address those there, because different jobs are different. Maybe this home, we have to operate a little differently. Maybe your insurance requirements are higher, whatever. You can address that, and it's a much easier agreement to get them to execute. So maybe it's a one page, maybe it's a half a page type of deal, and they're just executing that, and they're much more comfortable after y'all have kind of banged out that MSA.
Yeah, and if you're a contractor in Texas and you're a TAB member, there's a boilerplate version that you can use that's better. Is better than nothing.
Exactly.
That's the one that we use, and we took it and made a couple tweaks to it to suit our purposes. But it's a good document. But that that outlines how they're going to get paid, what the procedure is for them submitting invoices, and you send it on Friday, we'll pay you within X number of days after that. However you want to structure it. Insurance requirements, making sure that the subcontractor has insurance, which is very, very important too.
Something that you would think would be pretty basic, but you'd be surprised. It's just crazy. It's crazy.
We've lost a lot of subcontractors over the years who didn't want to get insurance, and we just had to say, as we've grown, as we've gotten more sophisticated, if you want to continue to work with us, you have to get your own liability insurance.
And let me say this too, while I'm thinking about it, because I've had some folks where they've kind of gotten burned. All insurance isn't equal, right? And so you got to make sure that the sub has the insurance, that they name you as an additional insured, right? But you want to look at that policy to know these exclusions, because some of these exclusions are wild that I'm seeing. I've gotten cases where we've gotten some significant, judgments, some significant awards or what have you in arbitration. And then it's like collecting if it's a sub, unless they're a significant sub, a lot of times you're not going to be able to recover, right? And so you rely on that insurance. You rely heavily on that insurance. And so if there's an exclusion, you got, this is a your work exclusion. It's the work that the sub performed, and so we're not covering that. That's tough, right? So you definitely want to make sure that the sub has, not only that the sub has insurance, but you understand what the exclusions are, and to the extent that you're able to, you get some of those exclusions eliminated. You want to make sure that basically, if the sub is performing defective work, you're able to recover, and that if the policy is written in a way that doesn't allow that, you're kind of you're gambling a lot more than you realize, even when you have insurance. Because a lot of times people think just because the sub has insurance that they're going to be covered, and I get down the road and I'm like, hey, we're going to have to fight with the insurance in order to get recovery, right? So just something to think about.
Yeah, and that's extra hours that they're paying you,
Exactly.
or another attorney to fight with the insurance company over that, which is going to come out of their settlement.
It's nothing more frustrating, man, than when you get, like, for clients, it's nothing more frustrating than when they win, but they ultimately lost, because they've got what we call a moral victory. You've spent money on attorneys, you've gone through and spent all this extra time, you spent money on experts. You've got a piece of paper that says you won, but there's nowhere to collect the money from, or you can't collect the money. It's frustrating for everyone, because it's frustrating for me even. Yes, I may have gotten paid, but I don't like having clients feel like they got the short end of the stick. So even though I've won and I get to, we won, so on and so forth, collection is very important, because the ultimate goal is not just winning at trial and getting a judgment. It's making your client whole. Right? That's the whole reason you do it. You want to try to make your client as whole as possible. And so I think that on the front end, you want to definitely make sure that the insurance is in place, that the liquidity is in place, that you're working with companies that have skin in the game. Because if not, that's just an increased risk to you as a builder or a homeowner, depending on which one you are. You need to understand that if these folks don't have insurance and they don't have the capital or liquidity, they could just file bankruptcy, right? And then you'll never see a dime. And so that's added risk. And you have to, I'm not saying you don't do business with them, but what I am saying is you need to understand that risk so that you can plan for it. So
absolutely. All right. Well, I think that's about all the time we have for today.
Cool. Well,
so Kenneth Stevens, I apprciate you joining me today, and always good to see you. So real quick, give a plug for your company, website, your social media, all that stuff that you want to throw out there.
Yeah, for sure. Stevens, Reed and Armstrong, PLLC. Like I said, we're a litigation boutique here in Houston. You can check us out at SRA PLLC.com. We have an office here in Houston, and we actually recently opened an office in Dallas. I think it was like late last year. Strong litigation firm, growing, mostly commercial lit stuff. So like I said, we like to say if it's a civil dispute involving two businesses, we will definitely take a look at it and see if we can get involved. We've got a pretty healthy team of about 13 lawyers now. And so, we can handle most matters very, very easily. So give us a call if you need representation, and we're happy to take a look at it.
And also Pure Noir Urban Winery.
Yeah, for sure. Now, if you're downtown Houston or future Victory Park, Dallas, if you are into wine or you're just looking for something different to do. A lot of folks that come to us are just looking for a different experience.
Date night.
Yeah, date nights, girls' nights. We get a ton of those, or they just kind of come out, and it's a wine tasting. So we're not a wine bar. We actually produce the wines, and so what it is just kind of very similar to California. You come in, or maybe Fredericksburg, you come in, you sit down, a wine sommelier or wine associate is going to give you a guided wine tasting experience, completely interactive. They're going to talk to you about each individual wine, how it's made, the grapes that are used. They're going to talk to you about the brand, and then they're going to talk to you about our wine club, during the process. So we've got a very strong wine club. It's growing. We're really happy about it. They get all kind of perks and benefits. They're basically, the cool kids. So it's just kind of how that goes. So
awesome. And be sure and follow Kenneth on LinkedIn. Check out all the valuable posts that he puts out there as well. So again, thanks for joining me.
Yeah, thanks again, man. Thanks for having me.
And thank all of you for joining us on this episode of the Your Project Shepherd podcast. We will see you next time. Thanks. If you found us helpful and enjoyed listening, please support us by liking and subscribing here on your podcast platform, and also join us on our YouTube channel. We want to continue to bring you high-quality content and expert guests, and your support truly helps us to continue this journey. If you have any questions for me or my guests, or any feedback for us, you can email us at podcast@yourprojectshepherd.com. Thanks again.